Essentially, I'm a practitioner before the Supreme Court. And most of the cases I do, I must confess, are not environment. But I have an special interest in environmental work because my initial briefs when I was practicing before the Bombay High Court were having to do with environment. And as many of you can imagine, those briefs were free briefs. So these were public interest litigations which we did for a public cause. And of course, there were no fees, and they were looking for young lawyers who would sort of run around and help. So that was the start of my interest in environment in terms of litigation. And then I started, I'd done a thesis for my master's program in environmental impact assessment. And it slowly kind of expanded. So in 1991, I had the opportunity, and the work, of course, on this started much earlier, to come up with a textbook because the Bar Council of India, which is the regulatory authority for lawyers, they had prescribed a course on environmental law, but no one knew how to teach it because while environmental law it was desirable to teach it, but when it was desirable to teach it, there was no textbook for it. So, with a friend of mine, we sort of started putting together a textbook. And it was a very slim book because there were very slim pickings in terms of law and environment. So that was 91. In 2001, the second edition came out, which was a little fatter. And then in 2022, the third edition came out, and boy, it is so big. And the reason for this is, in part, that during this period, during this 3-decade journey, environmental law has now become a very, very complex and complicated field. So it's highly regulated now. That wasn't the case in the 1990s and the late 80s, when we were really looking for material in laws. What should we include in the book? And now the task is exactly the opposite. What can we exclude from the book without missing, the essence of the subject? So that's just the size of this book just gives you a sense as to how in not just the world of academia, but actually the world of law, environmental law has expanded, the number of laws has increased, the number of regulations has increased, and the challenges have increased. Now, turning to the subject of how informed is the Indian judiciary on climate change, I thought I should just give you a little bit of a background on the role of the judiciary and the environment. So, we had environmental laws, as probably some of you know, or most of you know, right from the 1970s. Actually, we had state laws even before that. But come in the 1970s, we have a Water Act. In early 1980, we have an Air Pollution Control Act. We have a Wildlife Act. And so the body of law is now gradually expanding. But no one was taking it seriously, these laws, until we had that very terrible industrial disaster in Bhopal. And in the wake of that disaster, there were huge reactions. There were responses. The legislature responded, the executive responded, and the judiciary also responded. And the judiciary was compelled to respond because the situation they found themselves in was that, hey, we've got this tragedy which has occurred in Bhopal. Thousands of people have died. And everyone is saying, including the government of India, that the Indian legal system is so slow and incapable that the government of India is suing Union Carbide in an American court. So that is, again, not a very strong endorsement of the Indian judiciary. So what happened as a result was that the judiciary also elevated the importance of environment. And so from the mid-80s, in the wake of Bhopal, and right through the 1990s, the Indian judiciary was amongst the most active anywhere in the world. It was absolutely unprecedented as to what the Indian judiciary was doing. What it was doing, first and foremost, for pollution control. So whether it was water pollution and the Ganga pollution cases which it took up, or whether it had to do with mining, or it had to do with air pollution. There was a case called the Taj trapezium case. And there's another case around Delhi. Delhi, of course, still struggles with air as clean and clear as what we have here in Wayanad. But the challenge was sort of accepted by the judiciary, and the judiciary started becoming much more interventionist. So basically, the job of a judge generally is to sit back and decide on a case at a dispute between two parties who are litigating before the judge. But what happened in the environment is that the court reversed the role in a manner of speaking. It started entertaining public interest litigations. So it wasn't a fight really between two individuals, but the task was the citizen coming and say that, look, you have all these great laws, but they're just in theory. Please do something about them. And please start enforcing them. So you may recall that you have something called the Forest Conservation Act of 1980, but it was virtually a dead letter law. Nothing was really happening in the field all the way till 1996. And then on 12th December 1996, in a case called T. N. Godavar 1, which actually started from Kerala in a manner of speaking, you had the court say, look, our forests are across the country in such a bad way that we are going to intervene and we are not going to allow any further deforestation until the national goal of one third of the landmass or 30% of the landmass is achieved and attained. And quite frankly, we have to sort of thank the Supreme Court and the judiciary with regard to that. So, with several things, the first actually environmental case, and I must give credit to the Kerala High Court for that. It started with respect to a project where they wanted to dam the river which carves out Silent Valley. And as it often happens in litigation, you may lose the case, but then so technically your case is dismissed. But because the journey in terms of protecting the environment is so complex and it's full of steps forward and steps back, that public awareness increases, societal awareness increases, the compliance costs and the costs from the point of view of the developer increase to such an extent that the government then starts thinking twice before embarking on a future project of that kind of scale. So the point is, the Indian judiciary became really hands-on through the mid-80s, 1990s, and into the early part of this present century as well. And this is important because they did 2 or 3 things. It's important to contextualize this in the context of climate change, but just to flag those 2 or 3 things. So first, there were laws and it required the enforcement of laws which already existed. Second, it required the government to bring in laws where none existed. So, for example, you have garbage segregation, and the garbage segregation actually took place because of a petition called Almitra Patel. So, the Supreme Court of India, there was a plague in Surat. Almitra Patel went to the Supreme Court and she said, hey, how can you have a plague in 20th century India? You can't have that. And one of the reasons is that we've got a really bad garbage collection system. So they compelled the introduction of new laws. I'm just giving you one example in a field like garbage collection. The most recent one, I might add, was about a week ago, when you may have read in the newspapers that the Supreme Court has sort of persuaded, but actually it was a direction, for the states in the national capital region to ban firecrackers. So you're likely to find notifications and laws which come in. So they've enforced litigation, they've really pushed and created laws in a manner of speaking, albeit indirectly. Third, because the court started making headlines, so many polluting units shut along the Ganga, so many air polluting units shut around the Taj Mahal, etc. It really elevated the importance of environment. So environment is actually there in the Constitution as a value which we need to protect. But it gave life to this particular element. It increased accountability. It brought in new regulations, as I mentioned. It increased public awareness. And it really, the court stepped in and started saying that, look, as far as natural resource preservation is concerned and conservation is concerned, that's a high national priority, which we must all endeavor to further. So this was, in a manner of speaking, the fruits which were sort of easy to pick, the low-hanging fruit, as they say. Now we're coming into the next stage. So I had mentioned, if you recall, that in the wake of Bhopal, there was a new law. The legislature responded, and what we have there is the Environment Protection Act. And the Environment Protection Act is really the essential vehicle through which the government of India makes laws across the field. So whether it is hazardous waste, whether it is air pollution, whether it is preservation of the coast, all of that comes, or whether it's that garbage collection which I mentioned, it all comes under the broad framework of the Environment Protection Act. Now, one thing the government didn't do, even though the Environment Protection Act envisages that, is it did not set up a national environmental protection agency. So there's a provision in the law by which the government of India could have created an agency to enforce the law, but it's chosen not to do that. It's probably a very complex issue because there are already state pollution control boards, and there would have to be some real assumption of power which lies with the states under our federal structure if you were to create an environment protection agency. But the reason in particular I mentioned the Environment Protection Agency and the lack of not having an Environment Protection Agency is because of our current theme of climate change. I think while the court could address those issues which are low-hanging fruit, when it comes to climate change, the science, as all of you know, is so complex. The interventions which are required are so many. The directions which you require, really, in terms of implementation, are not at a broad brush level where you say that, all right, I'll go after these polluting units on this particular river. It's across the country. And that's why I thought I should mention the need, perhaps, if we're going to really tackle environment protection when it comes to climate change and global warming, the need for possibly a national environment protection agency where the power already exists, or second, as most of us feel, or probably know, at least a few of us feel, that while we're not very good oftentimes at implementing statutes here in India, we're pretty good at working our constitution. So the time might also come for a constitutional amendment. And just as we have, say, an election commission of India, which is out there in the constitution, we have the Supreme Court of India, right there in the constitution, was created by the constitution. Maybe the time has come to really conceive and to debate and discuss as to whether we need some sort of a protector of the national environment at the constitutional level. Because these challenges of climate change are going to be so immense that I feel some sort of a knee-jerk or a band-aid kind of system through courts responding is not going to be a very successful model. So this is the level at which we need to think. Now, let me just change tack and to just tell you something more about where the question is as to whether the Indian judiciary is well informed on climate change. So I'll just move to the next part of the talk. And that is really with regard to who are the judges and who's deciding all this. So the stories which I gave you about the 1980s and the 1990s was essentially at the High Court level and the Supreme Court of India level. But there's been a change in our dispute resolution infrastructure or architecture, and that has been the creation of the National Green Tribunal. So we have a National Green Tribunal Act. And now most of the green cases come up before the National Green Tribunal, and then they hop up in an appellate forum, which is the Supreme Court of India. And if you ask me as a practitioner who doesn't very often go to the NGT, I have very limited experience there, but I get an occasion both as because of my academic interest in environment. And also I was a practitioner before the Supreme Court to see the orders which come out of the NGT. And the overall sense that I have is that the National Green Tribunal is not really delivering at the level at which it can, in terms of competence, in terms of ability, in terms of, reasoning and analysis. So while the NGT is a very powerful court, it's the quality of its judgments is not the same. It's not such that would engender respect. And that's a sort of a complex area, but I see over there a lot of scope for improvement. So yes, they might mention something about climate change and you should do X or Y or Z. But if you actually ask me whether the judges and the personnel of the National Green Tribunal have the capacity or indeed the understanding, since that's the question, well, are they well informed on climate change? I would say it's pretty limited. I would also say that from the standpoint even of the Supreme Court of India, because of the huge pressures which operate on the Supreme Court of India in terms of the number of cases, it's over 80,000 cases that's on their roster. The time is shrinking. And on issues like climate change, there is an education which has to be imparted. So where do judges learn from? Of course, from the general, from their readings, etc. But essentially, it's from members of the bar, which is the lawyers who are presenting cases before them. And I think on complex issues like climate change, if we're going to get into the nitty-gritty, it's going to be a long and slow learning curve as far as the Supreme Court is concerned. Have they mentioned climate change in their judgments? The answer is yes. So, in fact, the first judgment I could find is 2006. There's a reported case of Bombay dying versus the Bombay Environmental Action Group. And it mentions that our cities, etc., will have to respond to, climate, challenges of environment, including climate change and global warming. So, in that sense, there is a passing reference. There's now a very detailed judgment which recognizes and discusses climate change. I don't know whether any of you are aware of it. It's called the Great Indian Bustard case. Does anyone remember that? All right, so I'll tell you about it. So the Great Indian Bustard is this magnificent bird. We're down to just 100 in number. All right, there are just 100 Great Indian Bustards left. The beauty about the Great Indian Bustard, apart from it being, a megafauna and remarkable, it's the heaviest bird in the world capable of flights. So it's the heaviest bird which can fly. So it's really special. And the case before the Supreme Court was, hey, how can we on our watch, where judges are giving talks and lectures and judgments on environment, surely on our watch, we can't let this magnificent bird, get extinct. And the Supreme Court realized it, and so it entertained this petition. And one of the things which was killing these birds was the overhead power transmission lines. So the court has created an enclave in Rajasthan and Gujarat where overhead transmission lines, unless absolutely necessary, are not to go, because the birds die of colliding with these particular transmission lines. So anyway, so this was the order which the Supreme Court passed in 2021. In 2024, they revisited. And the reason they revisited was that the government of India came before the Supreme Court and said that we have this enormous climate change goal, which the nation, the Prime Minister has committed globally in terms of renewable energy. And to evacuate that power, we need transmission lines through Rajasthan and through Gujarat, because a large number of our solar power stations or the solar generators are located over there. So there's now a haggling going on in the Supreme Court of India as to how to do it. That case will come up sometime in 2025. But the Supreme Court used this occasion, Great Indian Bustard's second judgment, to say that there has to be a consciousness of climate change aspects. We have to be, therefore, while we will look after the Great Indian Bustard or endeavor to do so, we must also be conscious of our climate goals We have to engage in balancing, and therefore they constituted an expert committee to look into these particular aspects and issues. I want to sort of end with an aspect which has nothing to do with climate change as such, but it has to do with the general education of judges and the judiciary. So, how well informed are they? So, I want to just share something that I witnessed, and this was in the early 1990s, before most of you were born. But there was a terrible thing called HIV, which was sweeping across the planet. And people were dying because it was full blown AIDS. The immunity systems were compromised, and there was no cocktail of drugs available then to really respond to this HIV. There was also an association at that time linking it, because if you have read about it, uh, this particular it wasn't a disease, but this impact of HIV, this viral attack, was affecting the gay community in many parts of the world. So it was being associated with the gay community. And now that's the background. And now I'm taking you to, I think it must be 92 or 93, and we're in the library of the Bombay High Court. And we had two overseas jurists who were visiting at that time. One was Michael Kirby. He was a judge, but then eventually he became a judge of the Australian High Court. The Australian High Court is the same as the Indian Supreme Court. And the other was Justice Cameron from South Africa, and he eventually retired on the highest court of South Africa, called the Constitutional Court of Australia. And they were speaking to us lawyers, and there were 2 or 3 rows of judges. And I remember 2 or 3 things very vivid. They were both, and they declared themselves to be gay men. All right, that was one. So, that was a bit of a jolt. The second thing was, one of them acknowledged that he had, and he knew people who had HIV, but that he was on medication. And then at the end of the lecture, he went around shaking hands and hugging people. And he hugged a few judges of the Bombay High Court as well. And what happened after that was, you got a series of judgments of the Bombay High Court which were really progressive and really sensitive to issues. Because otherwise, you can imagine, it was like in the first few days of COVID. No one knew, and everyone was kind of really scared. But just this human contact, just the fact that you could meet and hug, resulted in these judgments. And then you may remember a case called Nas Foundation, which was delivered by the Delhi High Court, which decriminalized homosexuality in India. I mean, it was a path-breaking case. And one of the judges in the audience at that time really was the Chief Justice, who was part of the bench of the Delhi High Court. He was transferred, Justice A.P. Shah, who delivered that judgment. Now, what has this got to do with education and climate change, and whether our judiciary are informed? I think, apart from the education which you get in court as judges, as lawyers, I think these type of educations are really important outside of the courtroom. So I remember the first time when I spoke on climate change in the National Judicial Academy at Bhopal was around 2005, late 2005. And so there was a National Judicial Academy. They were informed about climate change, but it wasn't in a court setting. So I'll wind up by saying it's really incidents like these outside of courtroom, whether it's in a judicial academy or whether it's because of the lectures which I mentioned Justice Kirby and Justice Cameron gave, where you will be able to really lift the information levels, the sensitivity of our judges. I thank you very much for your time. Thank you.